Justice hasn't always been just in South Carolina, particularly in the Palmetto Low Country, where the powerful Murdaugh family ruled supreme for nearly a century. But as we saw in a courthouse up in Colleton County, South Carolina, and as we saw this week at the courthouse here in Beaufort, South Carolina, justice is now being served to Murdaugh. We're going to walk you through all the latest developments in this still unfolding crime and corruption saga as we start to enter the very end of that accountability phase. But we're also going to sit down with our Special Projects Director, Dylan Nolan, our producer, to dive into a much deeper discussion about South Carolina's badly broken justice system. It may have worked here, but is it working for you? And is it working moving forward? We're going to talk about that on a very special on-location edition of Your Week in Review. So we're beneath the Spanish moss outside the Beaufort County Courthouse here in Beaufort, South Carolina, the picturesque Palmetto State Low Country. This is a part of the state our media outlet has covered extensively for some time, but it's also a part of the state where a very prominent family reigned supreme for nearly a century. 3 generations of the Murdaugh family held the office of 14th Circuit Solicitor here in the 14th Judicial Circuit, including Beaufort County, the courthouse right behind me. The family wielded inordinate influence, not only on the criminal side with the cases they would prosecute or decline to prosecute, but also through the family law firm, or at least the firm that bore the family's name prior to the scandal that enveloped Alec Murdaugh. Now, if you follow this story, you know it's an international event. The double homicide trial earlier this year in Walterboro, South Carolina, where a Colleton County jury found Alec Murdaugh guilty of the murder of his wife Maggie and younger son Paul. That trial closed a significant chapter in this crime and corruption saga, although obviously we know that it is still unfolding. We've got an appeal of those convictions that Murdaugh has filed, and that appeal is actually on hold pending a motion for a new trial based on allegations of jury tampering. We've been covering those extensively at FITSNews, but the big news this week in the Murdaugh saga was the resolution of the state's financial crimes case against Murdaugh. Now, if you recall, Murdaugh had been facing over 100 financial charges alleging that he had defrauded numerous former clients, friends, law partners, his law firm, out of $10 million. Just a huge sum of money allegedly stolen over a period of more than a decade. And in court this week here in Beaufort County, as he has in courthouses across the state throughout this saga, lead prosecutor Creighton Waters from the Office of Attorney General Alan Wilson laid out in detail how Murdaugh effectuated his many financial fleecings of these clients. Now, the outcome of this financial crimes trial really was never in doubt, because during his murder trial, if you recall, Alec Murdaugh took the stand after Judge Clifton Newman allowed in all of the evidence about his financial crimes. He took the stand and admitted essentially to all of this behavior. So again, the guilty plea that Alec Murdaugh entered this week in Beaufort County, 22 different counts out of those 101. He was agreed to a sentence of 27 years. Now, this is obviously a much lower sentence than many of our audience were probably expecting, given the sizable sentence that Murdaugh was facing originally. Again, over 100 charges, potentially centuries behind bars. But the deal that was struck in Beaufort County this week, 27 years after Murdaugh pleaded guilty to 22 of those charges. Now, what was interesting about the big hearing today, coming into it, we had no idea that a plea deal would be reached. And in fact, that deal was not reached until Alec Murdaugh's attorneys and Murdaugh himself, who appeared in court in Beaufort County this week, signed off on the agreement. Now, Murdaugh will also have to pay restitution related to the crimes that he has now pleaded guilty of committing. Although an amount of that restitution was not set today, we still don't know exactly how much he will have to pay back to his victims. But what we do know is that there will be a hearing in this same courthouse behind me here in Beaufort, South Carolina, on November 28. And at that point, Alec Murdaugh's victims, as they did in federal court in Charleston, South Carolina, earlier this year, they will have a chance to be heard on these state charges. Now, it's expected that Judge Clifton Newman will accept the plea agreement, that he will accept that 27-year sentence that was agreed upon between prosecutors and Murdaugh's attorneys. But again, as we've seen in this case, if you follow the story long enough, you know nothing is certain, nothing is set in stone. So obviously we're going to be following that very closely. Our news team here, Dylan Nolan, our producer, video journalist Jen Wood, our research director, both of those two. I just can't can't say how proud I am of both of those two, the work that they have done on this story, not only this week as we dealt with these financial crimes and this pending trial, but also throughout this whole process. But one of the things I wanted to talk about briefly as we looked at this week as it unfolded, we entered this week with a lot of questions. If you watched our recent episodes, you'll know that the tensions in this case had gotten extremely, extremely high. The big reason for that, the judge at the center of all this. Judge Clifton Newman, as I've said many times, defined integrity, defined judicial competence during the Murdaugh trial down in Charleston, South Carolina. He was extremely even-keeled, knowledgeable of the law. This was a guy who was in command of that courtroom, did an amazing job. Now, after the trial was over, Judge Newman has said a few things, and again, I'm not disagreeing with anything he said. I think everything he said was on the mark, on the money. But again, he expressed clear opinions about Murdaugh, which according to Murdaugh's attorneys rendered him not unfit, I guess that's the wrong word, but incapable of being objective as a finder of fact in other Murdaugh-related matters. All right, so earlier this week, Murdaugh's attorneys filed a motion before the South Carolina Supreme Court. It's called a writ of prohibition, basically asking the court to prohibit Judge Newman from having any further involvement in any Murdaugh-related matters. Now, they based this motion on two key points. First, that Newman is a potential fact witness related to the allegations of jury tampering that are at the heart of Murdaugh's motion for a new trial on those double homicide charges. Now, the second part was that since that double homicide trial, Newman had expressed opinions about this case, which would render him unable to impartially serve as a trier of fact related to the financial crimes. Now, obviously, this was headed to, a potentially combustible situation here in the Beaufort County Courthouse, but the plea deal that was reached today rendered that moot. Newman now no longer has to decide whether or not to proceed as the judge in that financial crimes trial. Now, it's also going to save the taxpayers of Beaufort County and the state of South Carolina a pretty hefty chunk of money, because here's the deal, folks. Even before the double homicide trial back in January of this year, it was very difficult to find jurors who had not heard of this case. Now, at that time, it was still possible to find jurors who had heard of the case but were willing to set their preconceptions aside and judge impartially. And in fact, we were able to get a jury in Colleton County which did just that. We'll find out if that process was on the level here in the next few weeks. But here in Beaufort County, in the aftermath of that double homicide trial, the jury calculus was significantly different. Again, you had 6 weeks of this trial of the century here in the Palmetto State, broadcast to all corners of South Carolina, to the country, to the world. The most famous case, arguably in the history of South Carolina's judicial system. So the percentage of people who didn't have an opinion about Alec Murdaugh and the percentage of people who were able to set that opinion aside has obviously dwindled significantly. So we were looking at potentially weeks of jury selection here in Beaufort County ahead of this financial crimes trial. Also, we had no guarantee that that process would result in their ability to seat a jury. So we're looking at some very significant expense because we've got sequestration here, a lot of expense related to that, just the time that it would take to get to a jury here, clearly something that the state of South Carolina was eager to avoid. And also, as I mentioned earlier, Judge Newman eager to avoid having to deal with the questions that were raised about his potential ability to be impartial in this financial crimes case. Now, where are we in this story moving forward? Obviously, we've seen two of the biggest chunks of this story dealt with now as we enter into the accountability phase of the story. Obviously, we've talked about the initial phase of this, the investigatory phase, all of the drama that resulted from the double homicide, from the roadside shooting after that in Labor Day of 2021, which resulted in additional charges against Murdaugh, all the financial crimes, which heaped one on top of the other till we again reached over 100 different charges facing Alec Murdaugh. So where do we go from here? There's murder convictions. Obviously, we know what the deal is there. We're going to have an evidentiary hearing soon on those, whether or not the jury was tampered with. We're going to hear from those jurors. We're going to hear from them individually. We're going to hear from Clerk Becky Hill, who was accused of tampering with them. That's all going to be at a big evidentiary hearing coming up in Colleton County within the next few weeks. Now, that has not been scheduled, and the reason it hasn't been scheduled is now we don't know who the judge is going to be. With Newman recusing himself, it will be up to South Carolina Supreme Court Chief Justice Donald Beatty Beatty will now have to pick another circuit court judge to hear those motions, which again are pivotal, absolutely pivotal to the future disposition of this case. So we've got that coming up. We've also, on November 28th, as I mentioned earlier, got a hearing here at the Beaufort County Courthouse where Alec Murdaugh's victims will have their chance to speak. Those financial crime victims will have a chance to address the court, and Murdaugh also will have a chance to address the court. Now, one thing that is interesting, Judge Newman will preside over that sentencing hearing. And in fact, in the courtroom this week, Murdaugh's attorneys withdrew their motion to have him recuse himself. Now that the guilty plea has been entered and agreed to, they are willing to have Newman hear the sentencing arguments and impose, once again, a sentence on Alec Murdaugh. Now, some interesting moments in the courtroom this week. Dick Harpootlian was asked whether or not this story would ever end. Harpootlian's comment, very interesting. He said this case was like a sexually transmitted disease and that he thought it would never go away. A very interesting comment from Dick Harpootlian in the court today here in Beaufort County. But sometimes we felt like that with the Murdaugh story, folks. Sometimes it's felt like a story that would never end. But I want to tell you why it matters. I want to tell you why it's so important. This was a case where South Carolina had an opportunity on the global stage to show whether or not it could dispense justice fairly. And we're going to talk about that in the next segment, and I bring Dylan Nolan on to talk about what's happening with the bid for judicial reform here in South Carolina. But this was a big test. It was a test not only for the judiciary, it was a test for the prosecutors. And it was also a test for law enforcement. Now, how well did all of these groups do during the Murdaugh trial? Well, they got the result that mattered in the end in that double homicide trial, and the result that mattered in the end here in Beaufort County this week. But a big reason that we have focused so intently on this case is that this was a family, as I said at the outset, which had been dispensing and dictating justice here in the Palmetto Low Country for a very long time. And I think Creighton Waters, the lead prosecutor on this case, on the murder case and the financial crimes, who has done a masterful job from start to finish. I was able to speak to him briefly and congratulate him here in the aftermath of the guilty plea. Waters did an amazing job, but he articulated it here today. He talked about how at the very beginning of this investigation, so many people were scared to come forward because for years, for decades, again, for nearly a century, the Murdaughs had always won. It was like betting against the house, folks. You know what's going to happen. You know the outcome. Well, guess what? The South Carolina justice system, much maligned, and we're going to talk about that again in our next segment, but in this case, it showed that justice can be done, that accountability, even to the powerful, can be upheld. And Alec Murdaugh's sentences, both for the murders and for those financial crimes, stand as a testament to that. And one last word I want to say before we cut to the next segment. This news outlet published the very first editorial calling on Judge Newman to recuse himself. And I want to say something about that because we took a lot of heat for that column. But in that column, I noted that Judge Newman had defined integrity throughout this process and that he needed to do so again as it related to stepping back from those murder motions, the post-trial motions on the murder trial. Newman has done just that. And folks, you cannot underscore how important that is to the public's faith. Had he sat in judgment over those motions related to the verdict that he clearly articulated his views on, I think a lot of folks would have had questions. But Judge Newman, as he has from the very beginning of the process, he did the right thing. And again, as he did during the murder trial, he has now done again, restoring people's faith in the system of justice here in South Carolina. As we're going to talk about in a second, that is faith that we sorely need to restore. So shout out to Judge Newman for his decision this week. And now let's get to that conversation with Dylan about the latest on judicial reform here in the Palmetto State. All right, so I mentioned in the last segment that we'd be bringing Dylan Nolan in, our video producer, journalist, special projects director extraordinaire. And Dylan, I got to ask you, man, we've been talking about the broken judicial system in South Carolina. FITSNews has been railing on the lawyer legislators and their broken system of justice, but didn't we see it just work?
Well, we did see it just work, and you just gave me the biggest softball on earth because that is something that I wrote about this week. Believe it or not, I was in a House subcommittee hearing on a committee impaneled to give a judicial reform bill that the General Assembly might vote on. And there was a representative who asked Alan Wilson, the Attorney General, whose prosecutors were working behind us here today, if everybody's seeing Alex Murdaugh getting convicted of murder, because keep in mind this just happened, so he hadn't seen this yet, but whether his conviction for murder on live television was enough to satisfy the public that South Carolina doesn't need judicial reform. And Alan Wilson's a lot more mature than I am, because I would have said, "Are you stupid?" and pointed to 9 different examples. But what he did was say, very politically and in his prosecutorial voice, well, the answer is in your question. This was broadcast on live television. But he was making the point that there are larger issues that require judicial reform here in South Carolina. And I had the fortune of attending the subcommittee that has been impaneled to come up with a solution. But it was very interesting because this subcommittee is pulling people from all across left and right on the political spectrum, but it also is pulling some of the people who have been talking the loudest about the need for judicial reform, and some of the people who are talking the loudest about the fact that, or what they view as the fact that they don't need any judicial reform, that there is no problem in South Carolina. So to see all of these people sitting on the same panel and crossing the same witnesses, so to speak, made for a very interesting subcommittee hearing.
Well, let's kind of set the stage of what we're dealing with here, because we were talking earlier about these lawyer legislators. South Carolina, obviously one of only 2 states in America where the legislature picks the judges, but as we've noted, it's actually a little more incestuous than that. You've got this panel called the Judicial Merit Selection Commission, which is comprised of a majority of lawyer legislators. And they basically rig these elections before they take place, so they've got not only legislature electing judges, but this small little clique picking the candidates before the legislative elections.
Yeah, and this is something that solicitors David Pasco and Kevin Brackett, who we've done an interview with that y'all should check out if you're interested in this issue, but they pointed to the Federalist Papers, which very clearly, and I mean, this is something that's not even, you don't need the Federalist Papers for this, you need like Schoolhouse Rock. This is very basic separation of powers. If your judiciary branch is completely at the behest of the legislative branch, serving at their pleasure, obviously they're just going to be a vestige of the legislative branch, and that's what we have here in South Carolina.
When you pointed out, this was interesting, in the immediate aftermath of the Murdaugh double homicide trial, Dick Harpootlian went back to the state Senate, and he was on the floor of the Senate. I think it was the very next day after the sentencing. And the state senator, Chip Campson from Charleston, gets up and says, well, Senator Harpootlian, basically what I asked you earlier, didn't the system work? And did you get special treatment as a lawyer legislator? And he said, oh, well, no, of course not. But I think you hit it on the head, Dylan. You said, as the Attorney General told the panel, well, of course not, because the whole world was watching those proceedings.
I mean, that was such a stupid question. It's like, it's almost as if the cop lights you up, you see his lights in your rearview mirror, and then you decide to go faster. Like, you're not going to, once you've already been caught red-handed, continue committing the crime worse. Now, in South Carolina, anything's possible, but that luckily is not what we saw here.
Well, give us a little bit of a breakdown of some of these proposals. What are lawmakers? What is the Attorney General proposing? Where are we on a fix for this broken system?
It's interesting because what I think would be like a fundamental fix would be to go and actually amend the Constitution of the state of South Carolina. For those who don't know or haven't read the article, the Constitution that we are currently operating on was formed in 1895 after Reconstruction, when blacks made up the majority of the state's population, and the white folks wanted to make sure that if they were to popularly elect a governor, that the governor wouldn't have any real power. So they stripped all these executive agencies, things that you would see in other states or at the federal level, being dealt with by executive agencies, not just in the judicial system, but across the whole state government, and put all these things in the hands of the legislature. And that's something that, broadly speaking, is a problem across South Carolina government, and it's a reason for a lot of the inefficiency that we see, and it's a reason that the legislature has control over things which they simply don't have the ability to properly manage, because these legislators are part-time. They earn like $10,000 a year. So it's definitely a structure of government. Yes, $10,000. That's what they are legally earning, of course, yeah. They're earning more than that. But this structure of government broadly, one might argue, should be changed. It was formed for completely racist reasons, and it results in less effective government across the board. That being said, that's not what anybody's driving for, because that would be like a nuclear bomb if you were to ask the legislature to do that, and they of course would never cede that much power. So, and this is made very clear by the fact that they're asking for an inch compared to that. that would be a mile. They're asking for an inch. And what Attorney General Alan Wilson's very specific ask is that the governor might appoint some of the commissioners who sit on the JMSC screening or selection panel so that the executive branch would have some weight, so that it wouldn't just be the legislative branch weighing in on the judicial branch.
Yeah, that's right. And you're absolutely correct. FITSNews, for those of you who haven't followed our website for long, if you just started watching us on the Murdaughs, that is a huge issue that we've been raising, those constitutional issues. I did a document back in 2008 called the 95 Theses, which basically broke down point by point all the problems with that Constitution and how we needed to fix them, not only to make an independent judiciary, which was one of the recommendations, but also to restore that balance between legislative and executive, which is so important because we don't have a three-branch of government system in South Carolina. We got one branch.
Right. Henry McMaster is not just impotent because of his age. You know, it's constitutional in this state.
Well, we won't go looking in his medicine cabinet for a Viagra prescription, Dylan, but you're absolutely right. I mean, the problems that this lack of, checks and balances creates, I mean, we see it every day on the cases that aren't under the international microscope. Is that right?
Yeah, exactly right. The ones that people aren't watching are the ones that are the easiest to slip by. And I do have to say, pulling this back further, I speak with some of these folks who just don't believe that lawyer legislators get treated any differently. And by the way, every person who I speak to within the South Carolina legal community who thinks that is a legislator. I've spoken with Democrats, I've spoken with Republicans, I've spoken with nonpartisan political actors across the South Carolina bar, and the only folks who say lawyer legislators are not treated differently when they walk in a courtroom are folks in the General Assembly. That being said, what I hear when I speak with folks who are not pro-judicial reform or are pro-defense attorney is that there's a massive judicial backlog. And if you look at this ad hoc committee, which I was covering this week, one of the things that they're tasked with is dealing with magistrate reform, and they're also tasked with dealing with the general inefficiencies in the South Carolina judicial system. So it's more than just trying to address this power imbalance between the executive and the fact that they need to have some sort of weight in this process for us to have a proper balance of powers. But it's also looking at some of these other problems that exist within the South Carolina judicial system, which probably are contributing factors to our state having a very high violent crime and murder rate, and seeing if those can also be addressed comprehensively in a legislative solution that can be presented to the General Assembly this session.
Well, there are a number of proposals out there. I actually spoke with attorney Dick Harpootlian, who is one of the lawyer legislators, but he has actually proposed a bill in the Senate. He said he would be pre-filing it this year, ahead of the next legislative session, that would remove all lawyer legislators from that panel. So that's another one of the ideas.
Well, and you had spoken earlier about the rigging, and I believe that another part of this pre-file that he was speaking about is basically removing the ability of the JMSC to quote-unquote rig the elections by saying, okay, you're going to vote up or down, qualified or unqualified. And if they find a candidate qualified, they get to go before the General Assembly. Oh, and by the way, they're going to, if this becomes law, ban candidates from dropping out because the JMSC is notorious for bullying candidates, threatening their careers to force them to withdraw so that the commission's preferred candidate can proceed forward.
And one thing I do want to point out, Dylan had mentioned earlier in speaking about a constitutional solution, the position of this news outlet has been for a hybrid solution, which would require a constitutional change. What I proposed, editorialized in favor of, is having the governor of the state make these appointments, have the advice and consent of the state senate or hell, the entire General Assembly, whatever. But then every 2 years, the public plays a role through a retention election. So you basically vote up or down on that judge every 2 years after they're appointed. And if they get voted down, well, guess what? That process starts again. The governor appoints. We go through the process again. I think everybody needs to be a stakeholder. But Dylan, one thing I wanted to ask you, somebody asked me this once, and it kind of put me on the spot, and I want to ask you and see how you respond to the question. They told me, Will, if we start getting better outcomes from our judges, if we start seeing violent criminals held accountable, if we start seeing the Victims' Bill of Rights consistently upheld instead of trampled over, as we've seen numerous examples of, if we start to see those kind of fundamental changes where we restore the balance to the victims, not in favor of the accused all the time, on bonds, on sentences, on all these things, if we get better outcomes, do you care what the actual reform is? My answer was no, by the way.
That's a very interesting question. I'm going to kind of cop out and say that I don't think that we will see that change without reform, just because, I mean, I come from an accounting background, and I believe that a system which is structured that necessarily has a failure point will eventually be exploited. And so I believe in structuring systems that don't have failure points like that. Now, obviously, every system will be exploited, but you try to engineer systems when you're thinking about these things from a 10,000-foot view that are not easily exploitable, which is what this system is. So I believe we need to see some reform for there to be these positive outcomes. But in a world where we could have perfect justice and lawyer legislators could pick the judges, it wouldn't bother me.
Yeah. Well, let's talk a little bit about that. One of the examples that you heard at the hearing involved State Representative Leon Stavronakis. Now, obviously, our audience is familiar with this guy. He is very chummy with Circuit Court Judge Bentley Price, who arguably is the poster judge for accommodating violent criminals.
And the defense bar.
And the defense bar. And we had the story about how Bentley Price was in a courtroom. He was setting bond, was about to deny bond to a certain defendant. And then Leon Stavronakis raises his hand and basically gives him the, "Are you sure you want to do that?" look. And then the judge flips his decision right there in the courtroom. But you heard another example about Stavronakis and Price.
Actually, I don't know if this was in front of Price, or if we're thinking of the same one, but the one that really stuck out to me about Stavronakis, and yes, there are multiple examples, so we could be thinking of different ones, but the one that really got me was he appears before court, and for folks that don't know, legislators during the legislative session don't have to appear in court. They have basically a hall pass because they might need to be in the General Assembly doing legislator things. And that makes them very valuable as attorneys because often when you're facing criminal prosecution, what you're trying to do is buy time. So if for months out of the year you can avoid having to go to court because your attorney just doesn't have to appear, obviously these guys can just, on the face of this, bill more per hour. Even if they're not dishonest in any way, that is obviously going to give you a competitive leg up as an attorney. So he goes into court, and he appears before this judge, and the judge says, "Are you representing Mr. XYZ?" And he says, "Yes, I am." And the judge says, "Well, didn't you say you couldn't come to court today because of your legislative duties? We're trying to get this man taken into custody." And he says, "Well, yeah, but I'd like to waive it for this client who wants to enter a plea deal. She's been trying to for months." And the judge says, "Well, this doesn't seem to be within the spirit of the order," but the judge didn't have anything that they could do. And so he was able to take advantage of this in front of everybody in the courtroom, in front of the victims. It's just a disgrace.
It really is. And in fact, that immunity is what they call it, legislative immunity that Dylan was talking about. Chief Justice Donald Beatty issued an order nearly 2 years ago, which instructed courts to stop granting that immunity on certain cases, but the very next day sent an email out to those same court officials saying that order I publicly issued, don't enforce it. That's the kind of, again.
And let's just think about that. That means that there's really two options. Either Donald Beatty publicly issued this order with the full intent of rescinding it privately immediately after, somehow stupidly thinking that would not get out to the media immediately, or he was pressured. The Chief Justice of the Supreme Court, the highest official in the state's judiciary, was immediately got his phone blown up by a bunch of legislators and said, "Oh crap, I better undo this order."
System has to change. And in fact, we've got a report coming early part of next week on another lawyer legislator who is habitually abusing that privilege, not during the legislative session, but guess what, folks? They get it when they're not in session too. Pretty much any excuse you can think of, they can use it to get out of having to appear in court. And as Dylan said, that's a huge advantage for a defense attorney.
Yeah, I mean, it certainly helps you bill more per hour because who, if you're facing criminal prosecution, wouldn't want that?
Broken system. And again, we saw an example of it working this week in Beaufort with the Murdaugh financial crimes.
And we saw Dick Harpootlian, a lawyer legislator who, by the way, there's like 50 attorneys in the General Assembly, and there's probably 5-10 of these lawyer legislators that we hear about over and over and over again. And I think a lot of these ones who go to court and are honest and good and don't try to avail themselves of any of these privileges of being a legislator get really frustrated when news outlets like us come after lawyer legislators. But just because you're honest does not mean that everybody that shares your privileges is. And a lot of them are friends with the dishonest folks and don't want to look their friends in the eye and say, "Look, and you're the reason we have this problem here." But it's a fact.
Also worth noting, Dick Harpootlian could have invoked his legislative immunity for the entirety of Alec Murdaugh's trial. That was held, again, from January to the early part of March of this year, right in the middle of that legislative calendar. He could have very easily invoked that immunity, but he deferred it, declined to do that, and now, again, is one of the lawyer legislators pushing to take lawyer legislators off of that panel. So a little credit for Harpootlian on those issues.
Yeah, I think a lot of our audience sees him representing Alex Murdaugh, one of the least likable individuals ever to walk the face of the earth, and thinks that, Dick is a terrible person. I would encourage them to look at some of the other things he does, especially in his role as a legislator, because I think they might see him in a different light. I know that I have, the more that I learn about him on that side of things.
Well, he's certainly trying to move the ball forward on this issue that we're talking about with this committee. Now, I did ask Senator Harpootlian about whether or not he thought the House would produce a meaningful reform bill. He wasn't willing to go quite on the record, but he certainly gave the impression to me that he was not optimistic in the ability of the House of Representatives, led by Speaker Merle Smith, a lawyer legislator until recently was the chairman of that Judicial Merit Selection Committee. Not optimistic about the chances. So, Dylan, are you optimistic about these lawmakers giving up their own power to create a fairer judicial system in South Carolina?
I don't want to come out here and be extremely pessimistic and say that I don't think that they're going to do it, because if we were to have this conversation a year ago, the idea that there even would be a committee impaneled to deal with this issue would have been crazy. So, who knows?
Dylan, amazing work this week covering this issue. Dylan Nolan filed a big report on FITSNews.com that walks you through all of these different debates and factors that were held before that ad hoc committee. Alan Wilson was there, as you mentioned, solicitors Kevin Brackett, David Pascoe, all folks who have been interviewed by our news outlet. So again, check our YouTube page if you want to watch those interviews, but go to FITSNews.com where you can check out Dylan's excellent report on the judicial reform movement here in South Carolina. Great work, Dylan.
Thank you.
All right, that is a wrap for this week's edition of the Week in Review on location here in Beaufort, South Carolina. I want to thank Dylan Nolan, our video producer, our director of special projects, an amazing journalist in his own right, for sitting down with me and walking through a lot of these big issues. We're going to have a lot more of that discussion to come as the judicial reform movement moves forward. Also, be on the lookout for more Murdaugh news. That's right. We're expecting an evidentiary hearing on that double homicide motion for a new trial sometime in the new year. It won't be after Thanksgiving, it won't be before the Christmas holidays, but we're reliably informed to be on the lookout for that hearing sometime in the new year. So we will continue to follow that story as it unfolds. But until then, thank you for tuning into this special episode. Thank you for liking, for subscribing, and please, if you would, all this work that we do to improve this justice system, we can't do it without your help. If you haven't already, please consider subscribing to FITSNews.com, where you can find all of our coverage of these important judicial reform issues. Keep it tuned to FITSNews.com, and thank you once again for joining a special on-location edition of your Week in Review.